Tell us about wills, Simon. We were chatting off air about wills and the need for them, what we should do. I'm sure a lot of us don't have them, including me.
Indeed, look, the national stat is only a third of Australians have a will. Anecdotally, we think that about 80% of those wills are out of date. So it's a serious national issue, and it's one where there's not a lot of public or government education on the issue. So contrary to what a lot of people might understandably think, either not having a will or having a cheap on the back of an envelope will doesn't save lawyers work or save people money. It adds to estate litigation at the end of the day. Another big linked problem is that the amount of wills being challenged or the amount of assets being argued over once people have passed is on the rise every single year.
Well, that's incredible. A third have only got a will. That's amazing. The statistic in Australia. Why? I mean, is it price? I mean, we probably are driven by price if we see something cheap regarding getting your will sorted out.
Yeah, look, I think the concept of the will kit has actually done quite a lot of damage because on the one hand, it's sort of given people the idea that for, I don't know how much they are, $25, $50, you can get a will, when in actual fact you really are buying a flawed product. But I think it also sends a subconscious message that it's not important because it's such a cheap product and they're being seen as very disposable. You don't really need to worry about it so much. Whereas I would say to any Australian family or couple or individual with a few assets or a few complications in life, if you don't have one and it's not the right one, you will cause your family huge grief. You can't draft a will unless you're 18. We'll put that out there as the first point. Second, though, after that, it really comes down to the complexity of your affairs. We are drafting more and more wills for very successful, very young entrepreneurs, for example, or young people who have been left in charge of younger siblings and the money to look after them. So basically, if you have any element of complexity attached to your affairs, age is not really the issue once you're 18. It's what needs to happen if anything happens to you.
We were chatting off air, Simon, about, I was interested that we were speaking about the different types of wills. I didn't know that even existed.
Yeah, most people don't. Again, there's this big problem with a lack of public education on this. And so you have a lot of people who think they're safe because they've got a simple will. It leaves everything to, say, their husband or their wife and then equally to their children. But they're involved in a business, they've got a self-managed superannuation fund, they've got a family trust, or they're in a blended family. And very commonly as well, perhaps they know there is unfortunately some sibling rivalry that could lead to a bit of a tussle over estate assets later. And the simple will just is not going to offer any level of protection for that sort of scenario. So you then got what we're calling the modern will, and it tends to deal with all of, I guess, modern day living, all of the issues that I've just mentioned, plus a lot more. And then lastly, you've got what we are terming detailed estate planning, which is not just the will. It's looking at business succession planning. It's looking at a whole raft of issues outside of the will, enduring powers of attorney, etc., etc., when people's lives are very complex.
Answering all those tricky legal questions.
I'll do my best.
We've got Matthew on the line. Good morning, Matthew. You got a question for Simon?
Yes, good morning. How are you today, Simon?
Very well, thank you.
I've got a little bit of situation. I've got a family of my own, and I'm a little bit. My partner, my wife to be, is on my beneficiary list. And in the event of my passing, could my mother compete with that beneficiary?
Great question.
Just have superannuation and life insurance and all that.
Okay. Look, with super and life insurance, the best thing you can do is nominate either through binding death benefit nominations or simpler nominations in the insurance side who you really want to get it. But none of that means you shouldn't have a will, because there will always be some other assets outside of super. Life insurance does usually go into the estate. And if you don't have a will, even in quite simple scenarios, people don't realise that the government can then take over the allocation or the split of your estate. So I think unless your mother is dependent on you financially, she won't be the risk. Okay. Sure. So that won't be the problem. The problem will be that outside of super, you're going to end up effectively what we call dying intestate, and that means you don't have a will, and therefore the Administration Act steps in and tells your family who gets what, and that is usually not what you would have wanted to happen. So get a simple will, even if your affairs are simple.
Okay, so who would I go to a lawyer to go see a will? Because I've done that and it's quite expensive.
Well, it shouldn't be for something that straightforward. Firms with wills teams that do this day in, day out and have specialists on the job, they will be able to draft simple wills very cheaply, a couple of $100, through to modern wills, which do range dramatically. But they're for people with, let's say, more modern lifestyles and perhaps quite a few assets, a business, things like that. And then you go right through to detailed estate planning. But that, again, is for people with very complex affairs. Simple will, look, if you spend up to a couple of $100, you'll get what you need, and it will last for quite some time.
Okay, now, I'm not saying you tell me now, but could you tell, I don't know, maybe send me an email and tell me who I can talk to?
Happy to do that. That's just, I guess, get in contact with 98.5 for that. They'll have a list of people and happy to help.
Okay, I'll do that.
No worries.
Great, Matthew. Thanks for your call this morning. We're with Simon Creek from HHG Legal Group. Got a question here from Alicia, sent a text message. And if my husband and I both die while our children are young and we haven't legally noted who we would like to be their guardians, what would happen with that?
Fantastic question. It's the answer here, I'm willing to bet, is not what people would assume. If both of you die at the same time as the parents, so you're in a car crash, a plane crash, for example, ultimately it is still the government who can step in and determine who your children live with.
Wow.
What you put in your will is really important because it's evidence of your wishes, evidence of what you would like to see happen to your children, but it's not binding. So sometimes in very, let's say, active families with quite a few issues, and where maybe different people might fight over who's going to look after your children, you should put an explanation as to why you've chosen X and Y to be the guardians, and why you haven't chosen someone else, because that will help the court or a government department determine whether to follow your directions or not. But either way, you must have that in your will. You must keep it up to date. It causes all sorts of problems when you put something down and then had a falling out with those people. And we in fact see this quite commonly. And so someone gets a phone call, look, you've been nominated as the guardian of these children, and they don't want to take the job. So it's awkward, it's very hard on the children, it's hard on the rest of the family, causes a lot of argument, and a lot of those matters end up in the family court if your will is not fully up to date.
Great advice there, Simon. And just to recap, I guess, what we spoke about at the start when we were speaking about wills that you can, I guess, the cheap ones off the rack, so to speak. Some suggestions there and recommendations, Simon, on that?
Absolutely. Let's just knock one bush rumour on the head once and for all. Lawyers make far less money out of wills than they do out of estate litigation. So by getting cheap wills, which unfortunately cause a lot of disputes in the courts later, you're creating work for the legal fraternity. You're not saving yourselves money. So get good quality wills in place. Don't use the post office will kit. It might work, it usually doesn't. Instead, go and see a lawyer. Make sure they specialise in this area, not someone who does bits and pieces of everything. Get it done properly. And a little rule of thumb with wills, the more money you spend on getting one done, the longer it will last. So a really good quality will, it might cost you, a few $100, but if it's going to last 10 to 15 years, it's actually cheaper than getting a really cheap one done every 2 years.
You get what you pay for.
You get what you pay for.